Hello and welcome everybody. Welcome back to my channel When Humanity is Life. In this video, we will be starting with the English explanation of the chapter on Introduction to Criminal Law. Now, we all know the definition of crime by now. Crime denotes an unlawful act, and this unlawful act is punishable by the state. Why? Because it hurts not only the individuals but also the state. And the body which deals with imposing punishments on crimes can be defined formally as criminal law. Now, a crime is forbidden or punishable by law. That's nothing new. And these are the words and these are the key points that you are going to mention whenever you are defining the word crime in criminal law. Now, we can understand the stages of crimes by this ladder. In the first step, we have intention. Next, we have preparation. Then we have attempt. And lastly, we have commission. Ordinarily, the first two stages of crime, intention and preparation, do not give rise to any form of criminal liability. Merely having an intention or making preparation for it doesn't make one a criminal. The moment someone's action enters into the domain of attempt and obviously commission, which means successfully carrying out the crime, criminal liability arises. So criminal liability arises beyond stage 2. Alright? I hope there is no confusion by this. Next we come to categories of crime. This is one of the most important boxes of this chapter. The first box on page 56, you need to do it. Alright, I hope that you are reading the boxes too with my notes, because that's also important. In your board exams, we are not going to take any chances. We will do everything that's there in the textbook. So without anything else, let's begin with the different categories of crime. There are 5 categories of crimes. First and foremost, it's against persons. These are personal crimes committed against specific persons, and it includes murder, aggravated assault, rape, robbery, and we can remember it as MAR. These are mnemonics which will facilitate your memory on the topic. Next, crimes can also be against property. Theft of property, like burglary, larceny. I make this mistake often. Auto theft, arson. Arson is fire damage. Alright? And we can remember it as ABLA. ABLA. Comprising of the different first letter of these words. Third category of crime is against morality. And this is a very interesting branch because there is no bodily harm in such crimes. Generally in crimes we have seen that people gets hurt and they complain to the police and the prosecution starts its action. But in this case of crimes against morality, there is no such bodily harm. There is no property theft either. And there is no victim in such crimes. There is no one complaining to the police against the perpetrators of crimes. In general, it's the state who takes suo moto notice and suo moto action against the criminals committing these crimes, because such actions will prevent the nonsense elements from continuing their illegal activities. Immoral crimes include things like prostitution, illegal gambling, and illegal drug trade. I hope you can see the screen. You can remember it as PII, P-I-I. I hope you know the meaning of suo moto. Suo moto means on its own behest, on my own. No one is complaining to the state for it. The state is on its own behest, starting investigation and punishing the wrongdoers. The fourth category is that of the white collar crimes. They are economic offenses. Whenever you hear about the word white collar crimes, always remember it's economic offenses. It can be of various types, obviously, and these offenses are done by the wrongdoers in their respective occupations. Examples are embezzling. Embezzling means taking money from one's own employer. Tax evasions without not paying a tax, which is also a crime, a very big crime, I would say. Insider trading. It's a instance of white collar crime. Then violation of income tax laws. These are all the examples of white collar crimes, and you can remember it as Vetic Bill. I know these mnemonics doesn't make sense, but I think this will help you to remember. And also, white collar crimes also includes corruption, bribery, and large scale scams. These are other examples which you can write in your answer. Then the last category is organized crimes. These are committed by structured groups and primarily involves distribution of illegal things in people. Examples of organized crimes are drug trade, illegal gambling, prostitution, betting on sports. In the chapter on contracts, you've already learned that wager, which is a formal word for betting, is a criminal act. Or illegal firearms sale, weapon smuggling, or even smuggling of any other things, money laundering or hawala transactions. These are instances of organized crimes. Alright, next we come to the elements of crime, the second subtopic of the chapter. Now see, the act of doing something bad or the guilty act must be accompanied by a guilty mind. I should have the intention to do something bad, and then only my action can be termed as a wrongful act. Now, wrongful act or the guilty act is formally known as actus reus in the legal parlance. Actus means a deed, it's an action or a conduct, and reus means it's forbidden by law. I hope you can see it. I will enlarge the screen for your benefit. Now, actus reus is the act of doing something bad, and mens rea, on the other hand, means ill intention, the bad intention to do something. Intention to do something bad means mens rea. And where do we get these two terms? Now, these two terms are embedded in a legal maxim, actus non facit reum nisi mens sit rea, which means an action doesn't make one guilty unless the mind is also legally blameworthy. That's the Latin maxim, and you need to write it whenever you're explaining the two elements of crime. Okay? Now, actus reus. Actus reus consists of three elements: an action or a conduct, the result of the action or a conduct, and such an act being prohibited or forbidden by law. Alright? Next, there are two examples here, two exceptions rather. These things apparently look like a criminal act, but they are actually not crime or wrong. Why? Because you see, an executioner's job is to hang. An executioner is a person who is appointed by the state who will prosecute the criminals. Actually, not prosecute. Prosecution is done by the state. The executioners, they hang someone to death. The accused who are receiving capital punishment, in most cases they are hanged to death. And this job is done by some individuals who are appointed by the government to do it. These are the executioners, and their job is apparently looking criminal. They are hanging someone to death, but they are not criminal because the executioner is simply executing his or her duty towards the state. Another exception is the job of the army man. The army man, we all know, the kills terrorists or the ones who are the foreign aggressors trying to move into our country. But our army kills those men to protect us. It's a part of their duty, and there is no actus reus in both these exceptions. Mens rea means intention to do something bad. As I already said, there are two constituent elements of mens rea. There should be a mind at fault, there should be an intention to do something bad, and the act becomes criminal when done with a guilty mind. The 2 points means pretty much the same, but you need to write them in a proper sequence. We also have an exception here. Now, an assailant who is trying to defend himself or herself, not assailant, I'm so sorry, person who is being attacked by an assailant. Assailant is a one who is an aggressor, who kills. If I am trying to protect myself from a danger, from someone who is attacking me, then it's not mens rea. Then there is no mens rea present here. My action is not wrong. But the moment an action is done for taking revenge, the act becomes criminal. Mens rea arises, and the concept of mens rea evolved in England in the 17th century. And mens rea is also incorporated into the provisions of the IPC, Indian Penal Code, which is the main source of criminal law in India. Now, from time to time, the Supreme Court in India has tried to establish that we have to consider menstruation as an important part of any law. The traditional rule of the existence of menstruation has to be followed. And this was established in two cases: State of Maharashtra versus Mayor Hans George case. Alright, this was fought in 1965. It's insignificant to remember the year. It's not important. Don't confuse yourself with so many information. And also in Kartar Singh versus the state of Punjab, the Supreme Court made a similar judgment that we have to include menstruation unless it's expressly or by necessary implication ruled out from a statute or a law. Alright, next we come to strict liability. Strict liability is the next part of the chapter. Strict liability is an exception to the rule of mens rea. These are also called vicarious or deemed liability offences, and examples are given in many special laws. Before doing that, we need to understand what is the meaning of strict liability. I will explain this with the help of an example. Suppose a company, it manufactures some product used by the consumers. Now, if the company suddenly manufactures an adulterated product or a harmful product which injures someone, which causes injury to someone, physical harm or in some any other way, then irrespective of whether the high ranking officials of the company, which includes the managers and CEOs and directors, irrespective of whether they have the mens rea, the intention to actually cause harm to the consumer, they are all strictly liable. They can be sued for harming the ultimate consumer in such cases. That's strict liability. Alright? This example is given in your textbook in a very detailed way. So, directors or any responsible officers of a company, if the company has committed any offense, are deemed to be the ones who are responsible for harming the persons concerned. Alright, this is the exact words of your textbook, and we are discussing the such acts which constitute strict liability or punished by some special laws. These special laws include Negotiable Instruments Act, Customs Act, Information Technology Act, and you need to remember the dates here because it's given in the textbook. Alright, it's easy. In 1881, the Negotiable Instruments Act was passed, Customs Act of 1962, and finally in 2000, the Technology Act, Information Technology Act, IT Act was passed. The third part of the chapter, third subtopic, is the difference between intention and motive. We often consider these two to be the same thing. We use these words synonymously, but they are not the same thing. Intention is the one thing that is considered in any criminal law. Motive is not considered. Now, what is intention? How can we define intention formally? Doing something intentionally means something that is done willfully and not accidentally or mistakenly. I have done something by knowing the consequences or the outcomes of the act. Whether it's good or bad, that doesn't matter. Alright, and this intention is the only thing required for affixing criminal liability. It doesn't matter if an act was done with good intent or bad intent. Suppose someone has stolen a loaf of bread to feed a person who was dying out of starvation, or a person has stolen medicine to save the life of a person who was dying. It doesn't matter whether this was done with a good intention. As long as the act was punishable, it was forbidden, and the person who has done it was full aware of the consequences of it. Alright? And what do you mean by motive? Motive, we can say, is the ulterior objective behind doing an act. It's a driving force behind intention. These are the keywords. These things that I've written in the notes, these are the keywords which you have to mention in your exam. I know that apart from that, you can create your own sentences, but these things are a must mention in your exam. Okay? So you can give this example which I've given right now. Stealing a loaf of bread for feeding a starving person, that's maybe a motive. But as long as the act was done knowingly, so the intention was to steal it, and we all know stealing or theft is wrong, punishable by law. That's why a person can be prosecuted and punished and sued. Alright? Next we come to the part B of the chapter. criminal law in India. This subsection deals with the branch of criminal law that we deal with in India. Now, criminal law in India serves 5 objectives. These 5 objectives are, first and foremost, retribution. Retribution means righting the balance. Now, you've learned the doctrine of retribution in the chapter on contract law. Here, the concept is pretty much the same, but we don't have any aspect of monetary compensation or any kind of money related thing in retribution. It's there in restoration. Now, retribution means righting the balance, as I already said. If a criminal has done something wrong, he needs to be given a penalty, so the criminal is punished. For instance, if a criminal has murdered someone, then capital punishment is given to him or her to balance out the suffering of the victim or the victim's representatives. That's retribution. Next, we have deterrence. Deterrence, something we are deterring, as in delaying. It's a major tool from the perspective of crime. Criminal acts are penalized so as to deter individuals from repeating it or even entering into it in the first place. A criminal, or a person before doing something wrong, something criminal, will think twice before doing that because they know that we will be punished once I do that. That's deterrence. Third is incapacitation. Objective is to segregate criminals from the rest of the society. For doing wrong things, they suffer a kind of banishment from the society. They live in prisons, they are separated from the mainstream individuals. That's incapacitation. Is a third objective of criminal law in India. Fourth objective is rehabilitation. The aim of rehabilitation is to transform the criminal into a valuable member of the society. That's the aim of rehabilitation. Often the ones who are put in jail or remand homes, there are many psychologists who meet them. They try to discuss things with them. They try to mold a good person out of the offender. That's how they are rehabilitated to become an acceptable and valuable member of the society. Last but not the least, we have restoration. Restoration is a victim-oriented objective of criminal law, and the goal of restoration is to repair through state authority any injury or damage inflicted on the victim, which means that if someone has committed theft, has stolen money from someone else, then that person is required to repay the amount to the victim. The victim gets back the amount of money that was stolen from him or her. When the money was stolen, the victim suffered a loss, but now the wrongdoer has to repay the victim. That's how the justice is restored in the society. So that's the last objective of criminal law in India. Next, we come to what is criminal law. The purpose of criminal law, there are 3 purposes first and foremost. The first purpose is to define a variety of crimes. Next is to prescribe a variety of punishments, and both these things, defining crimes and imposing punishments on them, both of these things are done by the Indian Penal Code, the IPC of 1860. Next, the third purpose of criminal law is to lay down some procedure which is to be followed by the police and later the prosecution. That's done in CRPC, the Code for Criminal Procedure. You can also remember it as Criminal Procedure Code if you have to have a consonance with the name, with the abbreviation. This was passed in 1973. Now obviously CRPC of 1973 is not the first criminal procedure code that we have in India. Before that we had the CRPC of 1898, but since it was obsolete, we have now enacted our own CRPC. Alright, it lays down rules and procedures to be followed in the proceeding, in the manner of investigation and the prosecution. Achha, let's move in a systematic way. Now, IPC 1860 is a very important source of criminal law too. Apart from IPC, the sources of criminal law also include CRPC, the Indian Evidence Act of 1872, which stipulates the kind of evidence which has to be admitted in court, what are the evidences that we need to consider, what are the things that we shouldn't consider or need not consider. Everything is laid out in the Indian Evidence Act of 1872. And apart from these three things, we also have some special laws like Prevention of Corruption Act of 1988, Food Adulteration Act, Dowry Prevention Act of the date I don't remember, Commission of Sati Act, which I think was passed in 1829. Alright, dates of these things are not important. You just remember the dates, the years of IPC, CRPC, and IEA or Indian Evidence Act. That's enough. Now, IPC was drafted after consulting various existent law codes around the world. Now, you won't be surprised that the legal justice system in India and whatever we have in the criminal area and the civil side, everything is heavily influenced by the Victorian tradition, as in the laws in existence in England. They have influenced our law to a great extent. And we can see that IPC was even enacted in 1860 when we were living under the British colonial rule. So definitely it includes a lot of things which were drafted by the British. But nonetheless, it is appropriate and apt for application in India. That's why we are still continuing its usage. And up till a few years ago, IPC was not applicable in Jammu and Kashmir, but now since Article 370 is revoked, IPC is also uniformly applicable in Jammu and Kashmir. Now, IPC consists of 23 chapters and 500 sections, and in each of these sections, first the definition of a crime is given and then the punishment. For instance, section 378 of IPC defines the offense of theft, and then section 379 defines punishment. The fifth point here, offenses listed in IPC, they are also punishable by special laws like ITA, Information Technology Act, passed in 2000, and the Prevention of Corruption Act, passed in 1988. This is done, and there is nothing else that's there in IPC. These are all the keywords, all the must mention points are given in the notes. Then CRPC, it includes the rules and procedures which has to be followed while investigating into an offense by the police, and also when the prosecution or the formal trial is going on. And based on the nature and gravity of offenses are classified into bailable and non-bailable offenses, cognizable and non-cognizable offenses, and compoundable or non-compoundable offenses. Bailable offenses are minor offenses, and here the offenders are the ones who are accused of committing a crime. They have the right to obtain bail. Non-bailable offenses are certain serious offenses where the accused has no such right to obtain bail. They can be given bail, but that will only be on the discretion of the court. Next, cognizable offenses, these are so serious that the police need not show any warrant. They can directly go and arrest an offender. They can start investigation on their own. Here, warrant is not required. In non-cognizable offenses, the police has to wait for the issuance of the warrant. They has to wait for the order of the magistrate to conduct their investigation or arrest the offender. Third, compoundable and non-compoundable offenses. Compoundable offenses are those which can be compounded, which means the wrongdoer can pay a fine to balance out the rule which they have violated. For instance, when we travel by train, there are some individuals who have not paid their money to buy tickets. In most cases, the checker in the train, they often compel the persons who have got into the train without buying the ticket to pay a certain fine. These are compoundable offenses. You should always, give the formal definition of compoundable offenses. You can write that whatever the offenses, the state which has conducted the prosecution and the accused who has done something wrong can come into an arrangement where instead of being imprisoned, the accused can pay a fine. That's the formal definition of compoundable offenses. But as we all know, not all offenses are compoundable. There are certain non-compoundable offenses. These are very serious offenses like murder. Obviously, it's not right that we can pay a money for murdering someone and can get away with it. definitely that will bring the society to a kind of a loggerhead situation. That's why not all offenses are compoundable, but there are some minor offenses that can be compounded. Next, we come to the stages of the prosecution of an offense. First and foremost, we have investigation. Investigation is the preliminary stage, or the first and initial stage conducted by the police. It starts after recording of FIR, or first information report, and it mostly includes ascertaining facts and circumstances in relation to the offense. There are 6 stages in investigation. First and foremost, proceeding to the spot where the offense is taken place, ascertaining facts and circumstances, arrest of the offender, the suspected offender, collection of evidence, forming an opinion. The police will form an opinion as to what had actually happened. Whether a prima facie case arises or not, these things will be decided. An opinion will be formed. That's the 5th stage. Last but not the least, the police has to report to the magistrate who is dealing with the case. Next, the second thing is the prosecution. Prosecution means it's a trial, the judicial adjudication of a person's guilt or innocence. Now, as I said, it's another word for trial. Trial. There are 3 types of trials, and there are 6 stages in a criminal trial. You should never forget the distinction between types and stages. Whenever it's types, mention the 3 types of trial. You are to mention warrant cases, summons cases, and summary trial. And whenever asked about the 6 stages of criminal trial, you have to mention all these points, like framing charge, recording of prosecution evidence, statement of accused, and all the rest of the things. If you can hear the sounds of honking, I'm so sorry, because I live in a very busy road. Anyway, so 3 types of trial. Warrant cases. In the warrant cases, the accused is punished with death or imprisonment for more than 2 years. And CRPC provides for 2 types of procedure for the trial of a warrant cases, either instituted upon a police report or those instituted upon private complaint. Summons cases are the ones which imposes punishments for a period of less than 2 years. And in summary trial, the accused is punished for less than 3 months. Alright, now the 6 stages of criminal trial. Framing of charge and issuance of notice, or giving of notice, it's the beginning of the trial. What happens here? The judge weighs the evidence. The judge looks into the evidence gathered by the police, and he or she asserts whether a prima facie or a primary case arises or not, whether it's dismissible or not. These things are done in the first stage. The next stage is recording of prosecution evidence. What happens here? The prosecution means the lawyer or the party which has been the sufferer. So that the lawyer of that party is asked to examine its witnesses before the court. This is called examination in chief. The accused has a right to cross-examine. The accused lawyer, who is a defender here, he can cross-examine all the witnesses presented by the prosecution. The CRPC provides that when the examination of witnesses once began in the second stage, or in the stage of recording of prosecution evidence, it has to be continued day to day until all the witnesses in row has been examined. Alright, now see, I have mentioned all the key points here. After writing these, you can mention the things that you can remember whenever you are writing the test or you are writing the answer. Alright, it's important to create a precise note. That's why I have not written unnecessary information here. You may feel that there are certain things that are missing here, like the sentences, the exact sentences are not written, the words, important words are given here, and I'm explaining everything. The third stage is statement of accused. The court has the powers to examine the accused at any stage of inquiry or trial for the purpose of eliciting any explanation against some incriminating circumstances. Incriminating circumstances are those which pressurize the accused to be a witness against himself or herself. That infringes upon the human right of the accused, and that is strictly prohibited in the Indian Constitution. In fact, under Article 20, we have a fundamental right not to be incriminated whenever we are charged for the commission of an offense. Now, here the statement of accused is without oath. The purpose of this is to give the accused a reasonable opportunity to explain such incriminating facts and circumstances in the case. The fourth stage is defense evidence. In defense evidence, what happens? The defense or the party which is accused, the lawyer of that party is asked to examine witnesses before the court. Now, most accused persons do not lead the defense. What this means is that the burden to prove the accused guilty is not on the defendant, it's on the prosecution. The victim has the liability or the burden to prove the defendant wrong. Why? Because in India, according to the rules, according to the law, the burden is cast on the prosecution to prove the defendant wrong, and this proof required should be beyond reasonable doubt. Then we have the fifth stage, final argument. What happens here? The prosecutor shall sum up the prosecution and the accused is entitled to reply. That's a final argument. For one final time, both the parties will have a debate and an argument on what the issue was and who was actually guilty or who was actually innocent. Lastly, the judge delivers the judgment. In this stage, the wrongdoer, the accused, is either acquitted, which means left without being punished, is released, that's what I mean, or the accused is convicted, which means finally subjected to punishment. These are the 6 stages. You take a look at this, you can take a screenshot of this. Alright, moving on to the next thing. The Indian Evidence Act. We're almost coming to the end of this chapter. Now, Indian Evidence Act stipulates how facts are to be proved through evidence. That's the one-line definition of the IEA. It was enacted in 1872. It gives us what has to be proved, how has to be proved, and it also talks about the burden of proof. Who has the burden of proof? As we all know, it's the prosecutor who has the burden of proof, and the degree of proof must be beyond reasonable doubt. Indian Evidence Act consists of 3 parts, and we will be doing about the 3 parts. Part 1, it consists of sections 5 to 55, and it deals with the relevancy of facts. What facts may or may not be proved. These things are mentioned in the part 1. Part 2 includes section 56 to 100, how the relevant fact is to be proved, how the matters are required to be proven, and how facts in issue are proved through oral or documentary evidence. Oral evidence as in a witness will speak on something, and documentary evidence obviously it includes documents and instruments. And part 3 of the Indian Evidence Act of 1872 includes sections 101 to 167, and it deals with the procedure for the production of evidence, by whom and in what manner. These things are given in part 3 of the Indian Evidence Act. Alright? Now, the main principle of the Indian Evidence Act is that evidence which are being presented in the court has to be confined to the matter in hand. Hearsay evidence, as in inauthentic evidences, are not to be admitted, and the best evidence needs to be given in all the cases. There are 2 main objectives of the Indian Evidence Act of 1872. First and foremost, to prevent inaccuracy of evidence, and secondly, to introduce a correct and uniform rule of practice. We must have a consistent rule of practice to include evidences, to induce evidences in a court of law, and it should not be arbitrary. Alright, now section 17 to 31, which falls under part 1 of the Indian Evidence Act, as we did right now, it deals with admission in general. And within the section 17 to 31, we have sections 24 to 30. Sections 24 to 30 deals with confession. There is a difference between confession and admission. Again, these 2 words are often used synonymously, but these 2 things are not similar. Confession is just a species of admission. It's just a form of admission. Now, let me objectively explain the difference between admission and confession. Admission is generally applicable in civil transactions and civil suits, and confession is generally used in criminal cases. Whenever a victim, not victim, whenever the accused or the wrongdoer is accepting his or her guilt, it's officially called a confession. And admission doesn't mean such acceptance. Admission merely means something that is said or admitted in general in case of a civil case. Now, Justice Stephens, he wrote the Digest of Law of Evidence, and he defined confession in this. Here also you have got a confession, but you are not to write this confession in your exam. You can write if you want to explain Justice Stephens, but in general you should write that confession is an admission made by a person charged with a crime, stating or suggesting the inference, which means suggesting something, that he or she has committed the crime. The person suggesting that he or she has committed the crime, it means confession. That's the exact definition which you must give. It's given in NCERT. Okay? Now we have this difference between confession and admission. Confession always goes against the person who is making the confession. Alright, now that's the third point more profoundly. First point which you need to write is that confession is a statement made by an accused person to prove something against him. Whenever an accused confesses his or her crime that goes against the person, confessions are always proved against the wrongdoer. And admission is about civil transactions, as I said. Anything about civil suits, it deals with admission. The admittance of something. I am accepting something. It's not my crime. It's simply a statement. And confession, if deliberately and voluntarily made, if it's made on the will of the accused, of the person who is accused, then it can be conclusive. It's final then. Admissions are not conclusive, however. Confession always goes against the person. This is somewhat a similar point, like point 1. And admission is often used on behalf of a person. If I am confessing my crime, it will go against me. But if I am making an admission, often it serves the purpose of, benefiting me. Fourth point, confession can be taken against co-accused if 2 or more persons are charged for the same offense. If 2 murderers have committed a murder together, then even if one of the murderers accept the offense, it can be taken as a full proof evidence against the other co-accused, against the other murderer. But admission by one of the defenders or defendants is no evidence against the others. Confession is a direct admission of suit. Even if you can't remember this definition of confession, then you can write this. It's a direct admission of suit. Either this or this. Alright, you can also include this point in your main definition of confession. Next we come to admission, the last point here. Admission means inference, which means suggestions about something. It's not a foolproof thing. It's not conclusive. It's not a direct admission. It's simply a suggestion, a connotation about something. Alright? With this we come to an end to confession and admission, the distinction. The last part of this chapter is on the forms of confession. There are 2 forms of confession: judicial confession and extrajudicial confession. Judicial confession is made to the court itself. Whenever an accused is accepting his or her crime inside the court, in front of the judge or the magistrate in charge of the case, that's a judicial confession. And when an accused makes the inference about his or her guilt outside the court, apart from the judge, to another person outside the court, it's extrajudicial confession. Now, extrajudicial confession can also include conversation to oneself. For instance, there is an interesting case here, also important case, Sahu versus State of UP. In this case, the accused was a father-in-law who was charged with the murder of his daughter-in-law. Now, this was made elsewhere than a court. It was made outside the court. Now, Mr. Sahu was seen by a person going out of his house by saying to himself that I have killed her, and with her all my issues, all my hassles. This was an extrajudicial confession, and this finally went against Mr. Sahu. He was punished. So we can define extrajudicial confession as a free and voluntary confession of guilt by a person accused of a crime in the course of conversation with persons other than the judge or magistrate seized of the charge against himself. So as I said, it's a confession made voluntarily by a person accused of a crime to someone other than the judge or the magistrate. The word judge or magistrate is often used interchangeably, right? Now, they can be considered if they pass the test of credibility. Now, extrajudicial confession can also include prayer or conversation to someone via a letter. Anything, any admission of guilt made to someone else other than the judge is the extrajudicial confession. Then, judicial confession is made to the court itself. As I said, it's a plea of guilty on arrangement if made freely and voluntarily by a person in a fit state of mind. That's it. There is nothing else in the chapter. And I will do the boxes once I complete all the chapters. In your midterm, I have only one chapter left, that's arbitration. And I will do it as soon as possible. So stay tuned with my channel. Please subscribe if you have still not done it. And thank you so much for seeing the video. Bye bye.